with something real quick, if you can.
Of course.
Yep, thank you.
Go right ahead.
Thank you.
Sure, all set?
Yes.
All right, this is Block 100 Limited Partnership versus Fidelity National Title Insurance Company, docket number 20-241CB. This is the time set for hearing on the defendant's motion for summary disposition that's brought under MCR 2.116 C8 and C10, and then there's also the plaintiff's motion for judgment under I2. And I'll first take appearances for the record, please.
Hi, Melissa Hagan. I'm here on behalf of the plaintiff, Your Honor.
George Brookover here on behalf of the plaintiff, Your Honor.
Stephen Hessen on behalf of the defendant, Fidelity.
All right, thank you. Mr. Hessen, your motion, you may go ahead.
Thank you, Your Honor. I think the parties have covered the waterfront pretty extensively with this, so I'll do my best to keep my comments brief. I do want to start by looking at the plaintiff's complaint, a couple paragraphs from the complaint. Starting at paragraph 12, the plaintiff alleges that in 2014, a dispute arose between the city of Lansing and Block 100 over the additional parking spaces, as a result of which, effective September 1, 2014, the city improperly terminated the parking declaration and parking agreement. The August 4th, 2014 city correspondence termination notice is attached as Exhibit 4. No notice was provided to Fidelity as a result of that, even though they knew about that in 2014. Paragraph 13 of plaintiff's complaint says Block 100, through its attorneys, contested these improper actions. See attached Exhibit 5. Discussions between the city and Block 100 resulted in an interim parking agreement, which became effective on September 1, 2014 and terminated October 31, 2014. The interim parking agreement is attached as Exhibit 6. No notice was provided to Fidelity. Fidelity was not asked to participate in any respect in the negotiation of that interim parking agreement. They weren't consulted as to whether or not that was something that was prudent in conjunction with the title policy at issue in this case. We have no idea whether or not that was a prudent move in the context of everything relating to the title policy. We were not consulted. Paragraph 20 of plaintiff's complaint says, on June 6, 2018, the Ingham County Circuit Court, entered a declaratory judgment granting the declaratory relief requested by Block 100. The declaratory judgment is attached as Exhibit 9. We didn't get a copy of the complaint before you even had received the motion for summary disposition that gave rise to the declaratory judgment. But you entered that order on June 6, 2018. Nothing happened in 2018. We never heard about this in 2018. It wasn't until, and you move down to paragraph 25 of plaintiff's complaint, on February 12, 2019, Block 100, through its counsel, notified Fidelity of the litigation and the city claims that the parking declaration and parking agreement were not enforceable obligations running with the hotel parcel, and requested reimbursement of attorney fees, costs incurred to date and in the future as a result of the litigation. Block 100's February 12, 2019 correspondence is attached as Exhibit 11. So they file a complaint, they file a motion for summary disposition, you grant that motion for summary disposition. That's in June of 2018. They still don't tell Fidelity anything about this. For whatever reason, 9-10 months go by. Finally, in February 2019, Fidelity knows for the first time that there's a lawsuit and that there's a dispute going on between the plaintiff Block and the city of Lansing. So fast forward now to this case. The plaintiff Block has filed a one-count complaint for breach of contract. Paragraph 32 says Fidelity had a contractual duty to defend Block 100's insured parking rights as established in the parking declaration and parking agreement, and or to reimburse Block 100 for the attorney fees and costs incurred to having to defend itself. Begs the question, how can we defend an action under any contractual obligation if we've never been told that there's a lawsuit or a dispute pending? There's no justification for the plaintiff's behavior in that regard. The paragraph 33 then goes on, of the complaint goes on to say, Fidelity breached those duties by refusing to accept the claim, provide a defense, or reimburse Block 100 for the attorney fees, costs incurred in having to defend itself against the city of Lansing. So the contract that is an issue is pretty clear. Whether you want to say a tender or you want to provide notice, that doesn't make any difference for purposes of this lawsuit or for purposes of this motion. They had an obligation, as soon as they found out from the city of Lansing that there was an issue, to let us know that there was an issue and to allow us to go through the process as provided in the contract to determine whether or not we should fight with the city of Lansing, settle with the city of Lansing, do whatever option that Fidelity deems appropriate in conjunction with the plaintiff block. That never happened. We never had the right to do that. Exhibits D, E, and F of our motion for summary disposition show all kinds of communications throughout 2014 outlining the dispute between Block and Lansing, and no notice. The contract that is in issue is not a McDonald's menu board. Block can't go in and say, well, we feel like it's best for them to, or best for Block to litigate for a while, and then we'll give notice at some point in time in the future. We put in our brief the relevant notice terms, and they blew every single one of them under any sense of reasonableness. This thing has been going on in excess of 6 years, and they never tell us about it. The way this is supposed to work, they're supposed to give us notice. Counsel is assigned, and Fidelity participates every step of the way through the litigation process and the claim process. They wait until, I venture to guess, 90 to 95% of the way through this litigation, and then they decide they're going to give us notice. And by doing so, they're trying to essentially reform the contract that is an issue, which is not appropriate. It's not justified. We need to look at the contract terms as stated in our motion for summary disposition. The contract is clear that notice without delay must be given to Fidelity so that they can provide a defense. Even paragraph 6, if there was going to be some arrangement relating to reimbursement for attorney fees or costs, requires Fidelity's written authorization first before that happens. So they can't even meet that condition preceding. The plaintiff spends a lot of time saying that they could not make a claim because they didn't know what the extent of their damages and liability would be. If that was a plausible argument, there would never be any insurance coverage prior to litigation because no one knows what an outcome of any litigation is going to be. The point of this is the city of Lansing asserted that they could terminate the agreement. They needed to provide Fidelity notice, and Fidelity gets to participate in this. And that did not happen. Also, I think that the plaintiff's behavior betrays this argument because in their first communication to us in 2019, they bring up the fact that their notice is late. They say that you haven't been prejudiced, Fidelity, and even though we probably should have given you notice earlier. They admit in that communication that they blew the requirements of the contract. If they didn't have to provide notice before, why did they try to do it twice in 2019? That's basically what it comes down to. For whatever reason, they didn't provide notice. So there are at least four times where notice would have been required. It would have been in 2014. It would have been before the suit was filed against the city of Lansing. It would have been before they filed the motion for summary disposition. And certainly after you granted the summary disposition motion, they still waited 9 months. So under any of those circumstances, the notice was not timely, and I believe that the motion should be granted. Thank you.
I have a question, because I don't think the plaintiff addressed this in their response, and it's you've made me wonder about it even more now as you've argued, because you say look at the contract language and that notice was required in 2014. But doesn't the contract say that it's litigation or a defense interposed in an action to enforce a contract? Isn't that the language? So isn't the notice only triggered by litigation? Or am I reading that too literally?
I think you're reading it too literally, and what we're relying on, Your Honor, I'll give you the specific paragraphs.
I was reading from 3A.
3A is if litigation is commenced by someone else against Block, which did not happen here. They were the ones that...
or a defense interposed.
Right. But 3B would be... I'm having a hard time finding I have too many pieces of paper in front of me.
Well, 3B has the same language. It refers to an action is begun or a defense is interposed.
Give me one moment to find the sentence, Your Honor. It would be in 3B. In case knowledge shall become to an insured hereunder of any claim of title or interest which is adverse to the title to the estate or interest as insured, and which might cause loss or damage for which the company may be liable by virtue of this policy. So it's in 3B.
Okay. All right. Thank you.
So it certainly there is a litigation triggering component to this, but it's with or without litigation, a claim should have been made.
Okay, thank you.
Yes.
Who's going for Ms. Hagan?
Yes. Good afternoon, and thank you, Your Honor. You know, the irony of this whole lawsuit is that Block 100 is asking for a fraction of what Fidelity could have been liable for had Block 100 not prevailed in the city lawsuit. The parking rights were insured for $18.9 million. Block 100's parking rights appraised at $10.2 million. Yet, and I'm not really sure if this is even true anymore, because I didn't hear Mr. Hessen say anything about prejudice, but you know, as a matter of law and as a matter of contract, that's the standard that the court has to look at today. Was Fidelity actually prejudiced by any late notice? And the case law does not distinguish between timeframes of delay. It just says, was there prejudice? Was the insurer materially impaired as a result of any delay in notice? And the 5-prong test speaks to whether the insurer was materially impaired in its investigation, in its evaluation, negotiation, defense, ability to settle the claims, those kinds of things. And the case law is also clear that an insurer, having received notice, delayed or not, must promptly act after having received that notice, and courts should take into consideration whether or not the insured actually did that, or whether they just sat back knowing that litigation was in place and did nothing. So what this court should be looking at, Your Honor, is whether or not Fidelity has brought any specific facts or evidence or proof to this court that it has actually been prejudiced. What would it have done differently if it had received notice earlier? What information or evidence was lost as a result of the delay? How would it have obtained a better outcome? And I suggested this court that it could not have. I mean, their Michigan case on point, in part because there is no prejudice when the insured has won. There is no liability that Fidelity is facing from a third-party claim. Now, as I said, there's no real Michigan case on point, and the Michigan courts haven't really spoke on that issue then, obviously, but the Wisconsin Supreme Court has, Your Honor, and we discussed the case in our brief, but in that instance, there was a 9-month delay in providing notice. And what the court said was, obviously, the insured was not prejudiced because the insured successfully defended the case. So you have to consider the fact of the outcome of the underlying lawsuit and the $10.2 million that Fidelity could have been responsible for, which they're not, because of the actions of the insured and their counsel. So Fidelity wants to discuss that maybe notice should have been provided in October 2000 or August 2014 when the city terminated the parking rights. But what Fidelity misses is that the city really didn't terminate the parking rights. The city never terminated, actually barred Block 100 from using the parking ramp. So there was nothing to tell Fidelity at that point. And despite the insinuations of Fidelity in this motion that there was some type of nefarious reason for not notifying Fidelity, I believe we explained that, Your Honor, in Mr. Phelps' affidavit, was that he didn't discover the endorsement to the policy, which provides the undisputed coverage of this claim until December 2018, at which point we did provide notice. So there's no ulterior motive or, like I said, nefarious reason for not providing notice before we did. But then once we did provide notice, let's look at what Fidelity did. They could have accepted the claim and provided the defense. There was 6 months, Your Honor, between the time that we provided notice and the scheduled trial in this matter. They could have provided a defense under reservation of rights. They could have filed a declaratory action requesting a ruling as to coverage. But what they did was they did a perfunctory investigation, which consisted of looking at their own internal title policy, the declaratory judgment that Your Honor entered in the policy, and they denied the claim. And they denied the claim based solely on paragraph 3 of the title policy, which, as Your Honor has pointed out, at least arguably requires that litigation be in place before notice is required. Now, as a side note, Your Honor, in the reply brief, and I just got the reply brief 2 days ago. The court rules require 4 days. So let me just place my objection on the record as to the reply brief as having not been timely served. But in that reply brief, Fidelity says that Mr. Lennon reviewed 135 pages of documents before denying the claim. Well, Your Honor, I have their document response right here. And 130 of those pages are their own internal title policy. They didn't review anything other than their own internal title policy other than what we sent along with the claim letter. So let us be clear that Fidelity took 2.5 months to not do any investigation and perfunctorily deny the claim. We asked them again, and we got the same story, except that this time the delay was 3 months, and all they did was reaffirm their earlier denial. So they haven't shown that they did any type of diligent investigation. They haven't shown that they have been prejudiced or materially impaired. Rather, they've prevented, because of the delayed notice. Instead, what they've given you is an affidavit from Miss Tiffany Beatty, a representative of Fidelity, which in and of itself is weird because Tiffany Beatty did not investigate or deny Fidelity's claim. Daniel Lennon did. As a result, Ms. Beatty's affidavit doesn't say that she has personal knowledge of what she says in her affidavit. What she says is she's familiar with the events of this case. So I don't even know if the affidavit is admissible. But nonetheless, what the affidavit fails to do is describe factually or specifically how Fidelity has been prejudiced. Instead, what it does is it just quotes the boilerplate 5-prong test from the case law. So the affidavit, Your Honor, is insufficient. And as we discussed at pages 14 and 15 of our brief, Fidelity could have done something at the time it received notice, and it didn't. The case was not settled. The issue of parking rights was far from settled. The city was still taking the position that it had the right to terminate the parking rights, and it was going to get Your Honor's ruling reversed on appeal. Now, the Michigan Supreme Court has spoken to this point in its case in Koski, when it said, we emphasize that an insurer who knows of legal proceedings instituted against an insured, but nevertheless chooses to rest on its claim of non-coverage, faces a heavy burden in demonstrating prejudice from its insured's failure to comply with a notice provision. Along those same lines, Your Honor, I recently found a federal case out of the Eastern District, Lower Town Project LLC versus Lawyers Title Insurance Company. And in that case, there was a 9-month delay in providing notice, and Lawyers Title said, you know, there's no coverage because there was this delay. And the federal district court said, no, we don't agree with that. You know, there might have been 9 months. The lawyers might have waited 9 months to inform Lawyers Title of the claim, but Lawyers Title has not shown that it was materially prejudiced by the delay because it had 3.5 months to do something to get in there and provide a defense or settle the case or take control of it, and it didn't. And in that case, the court stated Lawyers Title has not offered any reason why it could not have finished its investigation or participated in the settlement agreements in the 3.5 months. The same is true here, Your Honor. There's no prejudice. Fidelity had a duty to defend. It breached that duty, and now it's liable for all of the foreseeable damages, including attorney's fees and costs. And one other subject, Your Honor, that Fidelity didn't address, but I would like to take just a brief minute to respond to what they put in their reply brief, and that's on the issue of waiver. And Michigan is a raise it or waive it state. It's much like affirmative defenses. You don't raise it, you lose it. And under Michigan law, an insurer has to be specific as to the basis of the denial of coverage. I mean, it doesn't have to quote chapter and verse. And if you believe Fidelity's case law, it doesn't even have to cite the provisions of the policy, but it does have to give notice and some substantive reason and some substantive announcement of the defenses that it's going to rely on. And again, and that needs to be done in its first denial order. There's 2 cases directly on point that we cite in the brief. And if they don't do that, they're waived. And in this case, the denial letter cites paragraph 3 of the policy. It doesn't cite these new defenses that counsel was discussing in paragraph 6 or paragraph 4 regarding the notice of loss. It doesn't discuss any of that. And it certainly doesn't discuss this failure to tender a defense, which I believe I just heard Mr. Hessen admit is distinction without a difference, contrary to their brief, but I think that was an admission that that defense is meritless at this point. So there is absolutely no letter from Fidelity denying coverage in which Fidelity raises the notice of loss or failure to tender defenses, nor are those defenses raised in Fidelity's pleadings. They didn't even put them in their affirmative defenses, Your Honor, but now they raise them for the first time in this motion. But to bring the analysis full circle, Your Honor, these defenses do not have merit. So the determination of loss, there's some argument, I guess, that Fidelity should not be liable for attorney's fees because the city lawsuit was not carried on by Fidelity, and Fidelity did not authorize me and George to defend. Well, Fidelity can't deny coverage based on a breach of a duty to defend and then use that fact that the insured had to defend itself as a reason for not having to pay attorney's fees and costs. Moreover, that's not the law in Michigan. If you breach your duty to defend, you're liable for attorney's fees and costs, whether you authorize them or not. And the notice of loss provision, I think we've explained in our brief that the precise language is after such loss or damage shall have been determined. Well, that's what we did, Your Honor. We provided the notice of loss when we were able to determine what that loss was. Plain and simple. So I would answer any questions that the court has.
I don't have any. Mr. Hessen, I'll give you a chance for rebuttal. I will acknowledge first that I found your language that you're talking about and knowledge by the insured of a claim of title or interest which is adverse to the title insured and might cause loss or damage is also a notice triggering requirement. I'll acknowledge that. But rebuttal time, if you would like it, Mr. Hessen.
Very briefly. The first comment, Ms. Hagan is critical of Fidelity for taking 2.5 months or 3 months to respond to a claim that was finally asserted in 2019, which is laughable given the context that they don't make any claim in 2014 when they should have made it, which is their claim was, if it is in fact a claim, 5 years late. So I don't know how they can argue with a straight face that 2.5 months is too long, 3 months is too long when they waited 5 years. What was absent from comments by Ms. Hagan, she didn't address anything that happened in 2014. Nothing. Everything that she argued was relating to the lawsuit and whether or not they could have jumped into the lawsuit 6 months before the trial date, participated in discovery, whatever other arguments she made relating to the lawsuit. We think that the notice was late relating to the lawsuit, but we also have argued extensively in our brief, in my comments today, that it was late because of 2014, that they had several times along the way to provide notice under the policy and they never did. I didn't go into the prejudice argument because it's in the affidavit, it's in the brief. I believe that the best evidence of prejudice at this point in time is the fact that the interim agreement, okay, but let's not lose sight of the sleight of hand here that Ms. Hagan is trying to assert. A actual termination of rights letter was sent by the city of Lansing to Block. It's a letter that says, we're terminating this, it's over, which triggered any action that would have been necessary under the policy back in 2014. She then says, well, we didn't actually lose the right for parking. Well, one of the reasons they didn't lose parking is because they entered into an interim agreement. If you go to the Tenneco case that is both parties have cited in terms of what the prejudice standard is, the second point is that Fidelity suffered or was prejudiced to evaluate, negotiate, defend, or settle a claim or suit. What happened here was Block gets the termination letter. They have whatever negotiations they have. They evaluate whatever it is that they're evaluating, and they enter into this interim agreement without the participation of Fidelity. Fidelity had a right to be at the table, had a right to participate in those negotiations. That is absolute 100% prejudice, and that happened back in 2014. We did not have the ability to investigate anything back in 2014. We couldn't assess the damages back in 2014 because we never heard anything about it. We didn't even have the ability at that point in time, if it was in fact, if notice was in fact provided to us, to tell Block, well, there's no coverage under here for reasons A, B, and C. All of that was taken off the table. The contract is pretty clear as to what they're supposed to do. It is not triggered by litigation. It is triggered by an adverse claim against Block's interest. They didn't give notice. I think it's pretty clear now, based upon the arguments, they're going to take the position that, oops, we forgot we had this policy. That doesn't matter. It does not matter if they knew about it, didn't know about it, was acting inappropriately, or acting honestly. The bottom line is the policy has a clear notice provisions in it. They violated each and every one of them, and the motion should be granted. Thank you.
All right, thank you. Well, I'll get to what I think is the main issue in this motion later. I first would like to address some other issues that have been raised along the way in the briefing and also today. In the briefing, the defendant repeatedly asserts that the plaintiff waited to notify it until the plaintiff's rights were fully adjudicated, and that is just simply not true. Notice, of course, was given by way of a letter that was dated February 12, 2019. As of February 12, 2019, and after that date, the following occurred in the parking rights lawsuit. First, the city and the building authority switched attorneys. It was like a reset of the entire case, as I believe I noticed myself on the record at the time of the attorney switch, because the city had significantly dragged its feet on the entire case. And when new counsel came in, it was as if we were starting anew. Discovery at that point continued, or one might say began, because there had been, I believe, some written discovery done, but again, the city had dragged its feet on some responses, dragged its feet on its own discovery requests, and ignored the need for depositions. I would reference the plaintiff's motion to hold the city in contempt and to compel discovery, which was granted and resulted in an extension of discovery to June 21st of 2019. Also, discovery disputes continued. At one point, the plaintiff even sought a default against the city because of discovery issues. A non-jury trial was looming on August 26, 2019. And then a motion for partial summary disposition was scheduled and heard with respect to liability. The city brought a motion to strike an expert that was essential to the plaintiff's case. Depositions took place. The city proceeded with an appeal and was attempting to seek a stay. And the trial date was adjourned again to September 11, 2019. And probably the most significant event that occurred after the notice was given in February of 2019 is that, amazingly enough, the city, quote, acknowledged, end quote, this court's ruling, but ignored this court's ruling and refused to withdraw its notice purporting to terminate all of the plaintiff's parking rights. So not only are the defendant's statements inaccurate about the rights being fully adjudicated, and not only were they not fully, they were still threatened by the city's refusal to withdraw their notice terminating the parking rights, but we also had a trial pending on damages. So not only are the statements inaccurate, but the defendant's denial of the claim on the grounds that the parking rights were fully adjudicated as of February 12, 2019 is just not true. Next, the defendant says that the February 12th letter stated that the title issue was resolved and advised that the defendant would be provided notice of a further dispute regarding a title if a title issue arose. Well, what had actually happened was that the declaratory relief the plaintiff requested had been granted, but the plaintiff's complaint sought relief including money damages arising out of the attack on the plaintiff's parking rights. So that's why we were still pending and going forward towards a trial on damages. The February 12th letter informs the defendant accurately. It says the court resolved the parties' competing requests for summary disposition ruling that the parking rights declaration and agreement are legally enforceable, run with the land, and may only be terminated according to the express terms thereof. And then it goes on to say a court trial on Block 100's damage claims remains for determination before any judgment in the case will be final. So I fail to see how the February letter informed the defendant that the issue was resolved. I don't see that it said that at all. The other issue that was raised in the briefing, and now I think the defendant concedes, is the difference between tender and notice. So I'll just briefly address that because, like I say, I think the defendant concedes that now. But in the briefing, the defendant said that the plaintiff didn't seek a defense of the dispute and only sought reimbursement of attorney fees. But paragraph 3A of the title policy provides, that's the notice provision, and it provides the company at its own cost and without undue delay shall provide for the defense of an insured in all litigation consisting of actions or proceedings commenced against such insured or a defense interposed against an insured, etc., etc. And then paragraph 3B provides the insured shall notify the company promptly in writing in case any action or proceeding is begun or defense interposed as set forth in A above. So the terms of the policy require notice when an action or proceeding is begun or a defense is interposed under paragraph 3B, or as I noted already, I conceive, or when the insured has knowledge of a claim. But the provision in paragraph 3B in turn requires the defense of the insured under 3A. So there's no requirement that the insured, in addition to notice of the proceeding, has to also request a defense. And also that's not even a basis for denial anyway, so it was waived. Another waived defense is paragraph 4 of the policy, which was not a basis for denying this claim, and it's only now been raised. Even if it wasn't waived, though, the defendant's assertion now of paragraph 4 to deny coverage lacks merit. The defendant claims that paragraph 4 requires notice of loss be furnished within 90 days after, quote, a claimed loss first began to incur, end quote. That's from the defendant's brief. And the defendant says the loss began in 2014 and the plaintiff presented its notice of loss 1,991 days later. That is completely contrary to what paragraph 4 of the policy actually says. And I would also say it's completely contrary to logic and common sense. First, paragraph 4 says that the notice of loss must be submitted within 90 days after such loss or damage, quote, shall have been determined, end quote. It doesn't say within 90 days after it begins to occur. And that's where logic and common sense come in, because how could it? You can't state what your loss is on the first day it starts to occur in the case of an ongoing loss, such as here. So in addition to having been waived, that just simply lacks merit. But then we get to what I think is the real crux of the situation, because the time period alone, whether it's 1,991 days or however many days, is not really the issue. We can say it was 1,991 days. And the other thing that's not an issue is why the notice was late, because the policy doesn't require that the insured give an adequate reason why the policy was late, or why the notice was late. So it really doesn't matter if there was a nefarious reason or a valid reason or no reason whatsoever, because the policy provides that failure to notify shall in no case prejudice the rights of any such insured under this policy unless the company shall be prejudiced by such failure, and then only to the extent of such prejudice. So to me, the core issue is whether there has been a showing of prejudice. There are 5 factors under the law to consider when determining whether the insurer has been prejudiced, but there has to be a showing of actual prejudice, and it must be specific. That's really clear in the case that I believe was cited by plaintiff, Bibb, B-I-B-B, versus Dairyland Insurance Company. There was, of course, a much shorter delay in the notice in that case. But talk about the potential for prejudice. The insured in that case had been defaulted by the time that the insurer was notified. But there was a finding that there was no showing of prejudice, because it still is incumbent on the insurer to show actual specific prejudice. And here the defendant has repeatedly emphasized the length of the delay, but as far as actual specific prejudice, the defendant, by way of affidavit, has just stated the 5 prejudice factors as conclusory facts, instead of showing the actual specific prejudice. And that's probably because there is none, although the insurer is required to show the actual specific prejudice. The plaintiff has gone through the factors, and the court can apply them and conclude that the defendant can't show actual prejudice because there is no actual prejudice. Were they deprived of their ability to investigate liability and damage issues? Well, the defendant's representative reviewed, when they were given notice, reviewed the declaratory judgment, a title search, and the title policy before denying the claim. So the declaratory judgment did say it doesn't close the case. And there was, of course, much more to the story, as I've already outlined. But that's all that they reviewed. The information in the February letter alone should have triggered a further investigation. And at the very least, a little curiosity about the reference to a trial on damages would have certainly been warranted. So the defendant can't fail to investigate and then claim that it's prejudiced. Now, the second factor is, were they deprived of their ability to evaluate, negotiate, and settle the claim? Well, they had from February of 2019 to at least September of 2019, during which time at the end of which time the claim was actually settled. But defendant had notice starting in February of 19 and didn't do anything to try to jump in and evaluate, negotiate, and settle the claim. Now, the defendant says that it was denied that ability going way back to 2014. Okay, but you still have to show specifically how the defendant was prejudiced. As a matter of fact, the plaintiff back in 2014 successfully entered into an interim agreement that actually preserved the plaintiff's parking rights. So it is impossible for the defendant to show that it was prejudiced in its ability to evaluate, negotiate, and settle the claim back in 2014, when the result in 2014 was that the plaintiff prevailed completely in preserving their rights. Then another factor is the ability to pursue claims against third parties. Well, I think if it isn't already obvious, I remember very well the parking dispute lawsuit. It was quite memorable. And I like to think that I'm well versed in what was involved in the parking rights lawsuit, and I cannot conceive of a legitimate third-party claim. But again, it's not even for me to conceive. It's for the defendant to specifically say, well, look, there was a potential third party, and this is the potential third party, and we were unable to pursue that. Another factor is the ability to contest its liability to the insured. Well, its liability to the insured. The defendant made the decision to deny coverage when they could have defended under a reservation of rights and sought a deck action, or brought a deck action. But they didn't do that, so the defendant chose that risk. And then the last factor is the ability to contest liability of its insured plaintiff, that would be to the city. But again, they can't be prejudiced by that, because the plaintiff fully prevailed in the end in its lawsuit against the city. So as I already noted at the outset, the plaintiff requested judgment in its favor under I-2. I am denying the defendant's motion for summary disposition under C-8 and C-10, and I am granting judgment as to liability on plaintiff's motion under I-2, concluding that the defendant breached its duty to defend. The policy is unambiguous, and it has to be, as we all know, enforced as written. It provides this provision, as I've already read, about prejudice to the defendant. There is no prejudice to the defendant as a matter of law. The defendant is liable for all foreseeable damages, including reasonable attorney fees and costs. But of course, this is a judgment in the plaintiff's favor with respect to liability only, with damages to be determined. So for those reasons, I am denying the defendant's motion, granting the plaintiff's motion. And did someone submit? I don't think anyone submitted an order already, so if someone wants to do that, Ms. Hagan?
I will submit an order, Your Honor. I will send it to counsel first.
All right,
Thank you, Your Honor.
Yes?
I said thank you, Your Honor.
Oh, I'm sorry. I didn't see who was talking and I didn't hear you. That'll conclude our hearing. Thank you, everyone.
Thank
for
you.
your time, Your Honor.
Bye-bye.